Hi, everyone. I'm Jen Leonard, Executive Director of the Future of the Profession Initiative. It is finally sunny here in Philadelphia. I hope it is wherever you are as well. It's a great day to talk about the future, so welcome to the final installment of our Reimagining the Future of the Legal Profession Spring Series. Today, we'll focus on the future of lawyer formation, a discussion our Dean Ted Ruger will lead. Our format today is a little bit different from some of our other programs, with Ted and Emphasis President Ravi Kumar framing our discussion with a short one-on-one chat about the future of work and education before we dig into topics specifically related to the legal profession. We'll also host an informal post-webinar discussion from 4:30 to 5:30 Eastern Standard Time, so all of you can meet and exchange your thoughts on the conversation you're about to hear. More on that toward the end of the panel, but first, a few brief housekeeping items. We want to know what you want to know about, so please share your questions in the Q&A and upvote the ones you'd most like to hear our panelists respond to. 3L student Linwood Shaffer will monitor your questions and will ask our panelists a few of the most popular ones at 4 Eastern Standard Time. We'll be announcing CLE codes twice per hour for those who are seeking credit. You should write down those codes, and when the event ends, you can enter them on your digital evaluation form, which is mandatory to secure credit. A link to the evaluation is in the chat. To secure both credits of CLE, attendees must attend the post-webinar breakout discussion as well. And now here's the first CLE passcode. The passcode is geography, GEOGRAPHY, geography. And now, without further ado, I'll invite our moderator and our first guest to join our conversation to kick off the discussion. Please welcome our Dean, Ted Ruger, and Emphasis President, Ravi Kumar.
Thank you, Jennifer, and thank you for your leadership and organization of this event and so much at the Future of the Profession Initiative here at University of Pennsylvania Carey Law School. I feel fortunate as Dean to have, to be welcoming experts like you'll hear from today. One thing we believe in both our coursework and increasingly in the way we think about legal education here at Penn Law is that we can and should learn from other disciplines. Law has much to learn, and so we're very happy with our first guest, Ravi Kumar, kind of bringing insights from the business world and others. And so, Ravi, welcome, and I know you're with us for a short time, so let's just get right into the questions. I've heard you talk about the linear design of education and work that emerged over a century ago during the Industrial Revolution. What was so well designed about that linear educational thing, and why do you think continuous linear lifetime learning is the new model for learning and work?
Thank you, Ted, for this opportunity to talk to you, and thank you, Jennifer, for setting this up where I get to talk to such a uniquely different audience, which I don't get to talk to every day. But that kind of also reflects on how much you're thinking about the future of legal education, and I really commend your effort in reimagining the profession itself to the order of the society we're all going to live in. I know this is an interesting question. I've done a lot of research. The Industrial Revolution, almost a century ago, created this linear model of work, education, and governments. Governments were the orchestrators, educators educated, and enterprises gave work. That was good when all of us had a job for life. The life of skills was pretty long. We are entering into an era, rather we entered into an era which is very digital in nature. Every business is getting disrupted by digital technologies. Every business is becoming a technology business. You've heard this many times. And there is no longer jobs for life. There is multiple jobs in life, multiple professions in life. Life of skills is getting shrunk. I'm a nuclear scientist. I will tell you the half-life of skills is getting shrunk. And in this journey, you cannot have this model of educating for the first 30 years of your life and working for the next 50 years of your life. That model is blurred. You're going to intertwine work and education. And that's because the life of skills is so short that you have to constantly learn to learn to unlearn, learn to relearn. And that's the era we are all in. The digital revolution already started that process. The health crisis accentuated it and accelerated it. Legal education has to rethink as well. Legal education will have to be foundationally done in schools, but you should create an immersive format which will allow you to come back to school on a regular basis. And as you come back to school on a regular basis, you create an immersive format which is intertwined with businesses, which is experiential, so that you could cope up with the order of enterprises, order of the society, and live with this constant change of skills and constant change of working models. So this linearity is gone permanently. We're going to be in a non-linear world of lifelong learning. And I'm pretty sure that legal education has to follow that journey as well.
Mm-hmm. Thank you. That's good advice. And I pick up on something you said a few minutes ago, that every business is a technology business. And I don't think we knew as legal educators that, yes, we are a technology business. And I think the other but certainly the pandemic has helped us realize that in ways that are going to benefit us going forward. I also think we learned something that even people who have been teaching or working in a certain way for, as some of our faculty have been 30 or 40 years, can, with amazing alacrity, learn new technological skills. And that's been heartening and gives me a lot of optimism. One thing I get asked about a lot is, what's the best background for law school? And we have had people who've had success from both STEM backgrounds as well as liberal arts backgrounds. One of the things you've done with Infosys, partnering with Trinity College, is to blend, try to reduce the divide between liberal arts and humanities students and STEM fields. And why is that important? Sometimes you hear, especially with the technology, that it's all about STEM degrees. What's the role for bridging that gap with the humanities and social sciences?
Ted, that's a great question, actually. I think the future, the past was all about solving problems in business, and that was what work was all about. The future is going to be about finding new big problems. Solving problems will be relegated to machines. We are going to go into an endeavor of humans plus machines. What I mean by machines is AI software. AI software will solve problems, and the human endeavor will be about finding problems. Finding problems will come from professions like legal, professions from like humanity, liberal arts. I actually say legal as well, because legal actually, in some sense, will start to transition from being custodianships of business to enablers of business. Remember, legal education is also about, thinking about new problems, thinking about new frameworks, thinking about ideologically, thinking about negotiation, thinking about the middle path. There are so many of these soft traits which make the legal profession so strong, that I think problem finding will be the endeavor for enterprises and not problem solving. You will find more problems so that machines can solve those problems. And that is why I'm so excited about the role of non-STEM disciplines in the world of technology and in the world of enterprise.
Thank you, and I'll resist any jokes about what I'm tempted to say about lawyers and law professors and students being very good at finding problems. But yes, I think we bring a different perspective. I can, and it's good advice. I can say from when I practiced law, that when clients would come to me, they didn't come with saying, this is a contract law question, what's the contract law doctrine, or torts or criminal law. They would say, here's the problem I have, here's what's bothering me, here's what I would like to do, can you help me? And so that thinking is what we try to train here, and your vision is what we're trying to operationalize more. We're going to hear from the next panel about a model of legal education that we're trying to change, that has been in place in many ways fairly consistently for most of a century. We're a profession in law where sometimes its authority rests on not innovating. We say, well, this is good law because it's the way people did it decades ago, and we like to look backwards. And so it's a challenge to change the legal profession. I think a particular challenge, legal profession and law schools. And what advice do you have from other fields and from your view of we lawyers, that how can you help us change faster? How can you help us catalyze change?
Thank you, Ted. That's a great question again. The law education and the legal framework is more important now than ever before. We've never had the head of a consulting firm being a lawyer before. Accenture's CEO was actually their legal counsel, the current Accenture CEO, and that's a reflection of how much important that profession is. While I know that the number of students who apply to legal profession is going down over the years, that's what I heard. I actually believe that it will have to go back to those levels where legal profession did play a very important role in enabling businesses. And I'll come to that in a few bullets in the interest of time. First of all, legal profession is going to move from custodianship to also enabler of business. That's an important switch. There are going to be a few people who will be custodians, but there will be a large number of people who will be enablers of business. The second important thing, there is a lot of backbone legal jobs which are going to come in because of the advent of data, advent of AI and machine learning software. Remember, the legal profession came in at the start when the contract came in, and the legal profession came in when the contract, when you wanted to check whether you were compliant to the contract. What happened in the middle was not with the legal profession. What will happen now is with structured and unstructured data, with AI and machine learning techniques, you're going to find trends, you're going to find patterns, and you're going to have legal profession immersed into the business of identifying things ahead of time rather than finding it at the end of the cycle. I keep telling my own compliance and the integrity team at Infosys that if you tell me at the end that this is what I found, it's of no use. If you tell me these are the patterns, and these patterns will lead to these consequences, and we need to fix it ahead of time. And that's why I think there's going to be a plethora of backbone jobs, legal backbone jobs, which are going to be pivoted on the legal profession. I also strongly believe that in the future, consumers of software will become producers of software. Producers of software will become consumers of software. And that will be the future of AI. And when that happens, you need legal inclusivity in every individual, every employee, every discipline. What I mean by that is not expertise. I don't want to be an expert in legal, but I want to know what are the rights and what is it that I can do and what is it that I can't do. Where can I stretch the boundaries where I cannot? And if everybody is going to be the custodian of software, unlike a small set of people, you will need producers of software to also have a legal inclusivity, if I may. So STEM disciplines need to have a 101 on legal. Every discipline needs to have, because they're all going to be custodians of those assets. Remember, I just came out of a meeting just a few minutes ago where one of my clients said the 30,000 customer care agents they have, only 5,000 will come back to work. The balance 25,000 are going to work from their homes. Now, what is it that they're going to take a part of your organization and going to be sitting at homes and you're going to entrust on them, the assets of the firm? What is the legal framework they all need to be? So it's much more democratized, and legal discipline is going to be much more democratized. Like financial inclusivity, you have to start to think about legal inclusivity. I did mention in my first question you asked, there is this legal foundation you need by creating lifelong learning, but you need to create immersive formats where practitioners can go back and keep learning about new things and keep reflecting back with educational institutions. I'll not be surprised if your law school and Infosys come together and build a course on legal in technology. Whenever I hear the Congress hearings on big tech, I just, it perplexes me on the divide. What the 40% of the Congress has a legal background, and a few percentage of the people in the tech have legal background, and you just see the divide because they don't understand each other, and they look very awkward in terms of asking the question and answering the question. That's because of the divide. That divide has to go away, because you need an immersive format. On one side you have you need experts, and you need to keep the purest discipline it is. On the other side, you have to make it immersive and inclusive, because of the immersive nature of software and technology. legal education has to become much more inclusive. So there are going to be a bunch of these changes which will happen. And based on what I'm hearing from the colleagues of yours who I have I've interacted with in the last few days, I believe you guys are on the cutting edge of at least thinking about that change.
Yeah, thank you, Ravi. And that's it. That we're committed to inclusivity and think about it on a lot of dimensions. But you've highlighted kind of this kind of knowledge-based inclusivity that I think, and we'll hear in the next panel, I think we do quite well with in our second and third year, and some of our new developments. The first year is still pretty traditional, but I'll also say, and to your point about the connections between law and government and business, and I think it's good news. Most law schools, including this one, after about a 10 to 12 year either decline or flattening, applications are up dramatically. The number of people who want to come to law school in this country for JDs is up about 30% this year. I think that reflects both a recognition that we need more, our rule of law is broken. We need more people who think about ethics and law, and that also there's opportunities kind of outside traditional law practice. And indeed, to something else you said, Ravi, the fastest growing single part of our educational enterprise is not about forming lawyers or full JDs. It's a 1 year degree we have called a Master in Law for engineers and software folks and doctors and nurses and people who work in these heavily regulated fields. And we've been too stingy through the last century as at law schools that we're not sharing legal education for people who could use a course or two or a half a year or something. And I would love to partner with Infosys on a course or a program. So thank you for being with us. Do you have any last words? I know you've got a...
This is very thought-provoking. I think it's going to change the way software is consumed in every industry. I do think this transition from custodianship to being the enabler of business, I think the legal profession will progressively move there. And thank you again. Looking forward to more conversations like this.
Thank you, Ravi, for being with us. And you've given us ideas and motivation, and I look forward to talking further.
Thank you.
So we'll continue this conversation with 4 leaders in legal education who I'm going to introduce now. So I would invite you, the 4 panelists, to unmute your video, and I'll just briefly introduce and we'll move in. So I'm joined now by 4 colleagues and friends, some of whom work with me and some work in other places at other law schools. But first, Danielle Conway, who's the Dean of Penn State's Dickinson Law, she is the first woman and person of color to lead that law school since its founding in 1834. She's also has a long and distinguished military background. She retired from the U.S. Army in 2016 after 27 years of combined active, reserve, and National Guard service, and is a leader I know well from both the Pennsylvania and the National Dean's Group on issues of access to legal education, bar examinations, innovations, inclusion, and is such a friend and welcome voice here. Sarah Pierce is a professor and head of our legal practice skills curriculum, so intimately connected to practice, and leads that program here at the Penn Cary Law School. She also, drawing on her own experience practicing law at Skadden Arps, doing corporate and transactional work for 13 years, she also is the lead professor teaching our capstone class for our JD MBA students, so knows well the interdisciplinary roles there. Professor Scott Westfall is professor of practice and faculty director of Harvard Law School's executive education program, and teaches leadership, design, thinking and innovation, and resilience to Harvard Law students, along with David Wilkins there, has kind of founded and led a highly visible center on the legal profession. He served as director of professional development with Goodwin Procter, a major law firm based in Boston from 2004 to 2013, and also worked in the consulting world at McKinsey in DC. Last but certainly not least, Jim Sandman is now happily a Penn Law colleague. He's a Penn Law alum, but now working remotely here as distinguished lecturer and senior consultant to the Future of the Profession Initiative. He has served as in private and public roles, managing partner of Arnold and Porter, general counsel to the DC Public School District, and then for about a decade until last year, president of the Legal Services Corporation of America. So embodies our commitment that's throughout the law school to not just thinking about innovation in law, but supporting students and launching them into public service. And in addition to his thought leadership work, he's also a great teacher at the law school, teaching professional responsibility and leadership in law, both at Penn Law School and I think this semester at Stanford Law School as well. So welcome all of you. Let me first, as I noted with Ravi, there have been changes in legal education in the past years and stretching back a bit, particularly in the second and third years, with respect to experiential work, smaller classes, externship. So we're kind of moving in some directions that at least have altered the classic 3-year model, what we call the Langdellian curriculum after Christopher Columbus Langdell in the late 19th century, over 100 years ago at Harvard. But it hasn't changed that much. And I want to start by asking each panelist about ways that you would like to see it develop and change. And so I'll go in turn. First, Danielle Conway, what would you like to see? What's one element you'd like to highlight for this group? And we'll start the discussion that way.
Well, thank you for having me, Ted. And to the panelists, it's wonderful to be here with you. So here is my one thing, my moonshot, if you will. I would eliminate racism, bias, and oppression in general in our society, but in law schools, the legal academy, and the legal profession in particular.
So I want to come back to that. I will come back to that incredibly ambitious and important goal. And we'll bring the other panelists in first. Scott Westfall, how about you?
Yeah, my perspective on this starts with the model for lawyer development that came out of, the Christopher Columbus Langdell model, primarily litigation focused, think like a lawyer training that was supported by the external model that Paul Cravath and the Cravath system of associate development at major law firms started out in the early decades of the 20th century. Basically, the deal was that law schools would teach you how to think like a lawyer. Then you'd go to a firm in the Cravath model and be an apprentice, and you'd rotate around practices. You'd learn over a gradual period of time about what lawyers do. After putting your head down, doing some hard work, you'd become a partner. Clients would always just pay for services rendered, and there was no pressure. They let law firms just do what they were going to do and handle all of their legal matters. And then the world changed. Law firms grew to scale, and the apprenticeship model broke apart. Clients became more sophisticated, and the in-house growth has been tremendous. So there's a lot more pressure on law firms now to have their associates be practice ready. And then correspondingly, they're pressuring law schools to say, you have to train practice ready people, and what skills are you teaching them so they're ready to practice? This think like a lawyer bargain we had isn't working anymore. And when we look at the outside world, we're seeing that problems are becoming much more complex and interdisciplinary. And that's one of the reasons law firms themselves scale, but it's also the reason that they need to be able to collaborate with a lot more other types of organizations to solve these very complex problems. Academia, of course, is completely isolated from that. And I'm thrilled that there's a capstone program that Sarah is leading with the JD MBAs, because collaboration across schools and interdisciplinary is incredibly hard. And as Ravi suggested, a lot of people need legal knowledge and training, and problems are very complex and interdisciplinary, yet we're very isolated. I believe that as we look towards a new model of legal education, we look at what do the best lawyers have and need. I think it's a combination of legal technical skills and expertise, that specialization that traditionally, law schools with the think like a lawyer and law firm apprenticeship models did pretty well. But then there's a whole other range of leadership and professional skills that allow them to work in an interdisciplinary way and to focus on building and leveraging networks, both for professional and personal success. So it's a three-part model. The one thing I would change to most immediately start making progress on moving towards that model is that we need to learn how to work in teams. We don't, almost all of legal education is individual based. And when faculty put people in teams, they don't teach them about how to work in teams. They just throw them in a team. And if you ask most students, it's a horrible experience for them because they don't know what teams are. My Harvard Law School executive education program pretty much exists because of the dysfunction that relates from that. We don't train students how to work in teams and then become leaders. And so they come to us years later when there's a lot of dysfunction and we're filling the gap trying to teach them.
So
then
we
later
would put you out of business if we law schools did
and
better.
I'll happily retire.
Okay.
Really
Yeah, I was gonna say,
happily.
it's not-
Because
all right.
also,
So thank you, Scott. Yeah, I think, and indeed, I already want to return to, I think, the connectivity between Danielle's point about producing anti-racist institutions and this teamwork point, because I think they do go hand in hand, and that would be part of the goal of both. And Sarah, how about you? I know you kind of share both of those goals from a prior conversation, but what else would you add to the discussion? And then we'll explore all of these.
Yeah, and it picks up on what both Danielle and Scott talked about, in that the system of education that we still have is one for a particular type of student developed 100 years ago. A white student from a liberal arts background from particular types of school, and it hasn't changed a ton since then, despite the fact that our student body population, our population of lawyers, and who our clients are, has changed and has grown with the rest of the world. And so what we've worked very hard to do in our skills-based curriculum is create a truly inclusive classroom environment that touches learners no matter background, right? And using different types of learning techniques to normalize struggle, to focus on true learning and growth rather than succeeding on one day in one 4-hour block for a particular type of grade, and instead using feedback and iterative processes and group work to do what you would really do in representing a client and solving a legal problem. And from my perspective, what that has done is normalize struggle, has focused on the growth. And it brings up all students, whether they're from that archetypal background or not. So instead of just having a learning technique that is best suited for a particular type of student, it's one that helps all. And there's lots of ways we can do that, I think, outside of the skills curriculum as well, and still hold true to those core teaching values of that first year doctrinal curriculum and build in ways of feedback and iterative learning and working together with others. Something that I hear from students quite often is, maybe I'm not supposed to be here. I sat in 1L doctrinal class and the things that the person on call said were so brilliant and I could never say that. And I said, they prepared all week for that 1 minute of being on call. Yes, you can. You absolutely can. But when that's the learning style for certain types of students, they feel that it doesn't include them. So that's the main thing I would change.
Thank you. Jim, so you've worked in both the most traditional kind of classical law firm settings and led a quintessential DC law firm. You've also seen the gaps in justice, and I think you're coming to take I've seen you in ways that maybe you're wearing a tie belies, take a very radical critique of our legal profession and legal education. So I'm interested in hearing what you would change.
Could I have two things if I'm quick?
Yeah, yes, there's plenty of problems.
First, I think we're teaching an idealized version of the legal system that is wildly out of touch with the current reality. The National Center for State Courts estimates that in 76% of all civil cases in state courts today, and 95% of all litigation happens in state court, at least one of the parties doesn't have a lawyer. That figure doesn't include family law cases. If it did, that percentage, 76%, would be even higher. What that means is that every case that a law student reads in law school is unrepresentative of what actually happens in the vast majority of cases in the United States today. I'm actually making an educated guess in saying that, but I would guess that every case a law student reads was litigated with lawyers on both sides. Otherwise, it's unlikely the judge would have been able to generate an opinion of the quality necessary to find its way into a casebook. The system is failing tens of millions of people every year, and not just low-income people, the middle class and small businesses who can't afford access to the system. It's a threat to the rule of law. When people look at the system and they see that it works only for the wealthy, that is going to lose public confidence and faith in the system, which will ultimately undermine the system for wealthy people as well. The second thing I think every law student and every lawyer needs to know that reality. Very few law students do. Most lawyers don't, because they're not in the courtrooms where so many people are unrepresented. The other thing we need to do is to go way beyond teaching students to think like a lawyer and be sure they know how to think like a client. Whether that client is a mother seeking child support or a Fortune 100 company doing a corporate acquisition. Clients have problems, not just legal problems. Their problems are usually multidimensional and require a multidisciplinary approach to resolve them. They need a problem solver, not just a legal problem solver. So a good lawyer today has to be able to recognize the different aspects of the client's problem and pull together the people from other disciplines and collaborate with them to get to a solution. We need to get out of the silo and out of the bubble we've built around ourselves.
Thank you. Well, thank you all, and it's a tall order to elaborate that. But let's move forward productively, and I'll shift up the order a little. So, but I think these really connect. You know, the concept of historically excluding large numbers of people and racism and sexism in the law. The way we structure the first year, which compounds that, the way we have this individualistic model. So maybe Scott, I'll ask you to respond to Danielle, and then Danielle, I'll invite you to respond to Scott and Sarah and Jim. You know, Scott, you talk about collaborative or teamwork, and you heard Danielle speak powerfully about reducing and ending racism in law school. And like, how does in your view, the individualistic classical model, how has that been exclusive? How has that perpetuated kind of implicit or explicit racism, and how could a more collaborative model that you advocated serve our goal that Danielle articulated of a more anti-racist or inclusive profession?
There's a strong theme winding through all of this very carefully, which is, you know, we have a system that was set up about individual performance pressure in the classroom. You know, there's a lot of gender bias that goes into the traditional Socratic method and the way exams are done, all of that. When you step back and look at the way the outside world does training and development and the way the outside world works in teams and collaboratively, there's a great body of research about diverse and inclusive teams who get along well together and work well together and are trained to do that far outperform homogeneous teams of experts. And it's not hard to teach people those skills, but we don't actually do it. Lawyers in all settings that I look at, public sector, private sector, work in what experts would call a hierarchical, loose working group. They don't actually form as a team. They don't have a kickoff launch meeting where they're getting on the same page about what are the goals of the project, what is everyone's background, what do people want to add to it, how do they learn and get ready to build trust in the team, understanding and appreciating each other's diverse strengths. We set students up in a classroom and we expect that from day one, first year, they can talk about very difficult subjects and feel included and heard. They're a team in that classroom, and we've done nothing to build trust amongst each other.
Yep. So thank you. And Danielle, to take, you know, when you listen to the other panelists and also draw on your own experience, what are some ways that, you know, you've issued a powerful challenge about removing racism from American law schools? What are some steps we could take today? And then what are some steps as you look ahead 5 and 10 years that might take a little more time that you'd like to see us start working on now to manifest in half a decade or so?
Thank you for that and for all the contributions from the panelists. I think the first thing that we need to do is really situate or position history. So as I listened to the other panelists, what I saw and what I heard really sort of stepped over one of the main challenges, and that's acknowledgement. So if you think about law school design, you have to know and you have to be aware and willing to accept that this law school design was built on exclusion, reinforced by slavery, by slave codes, by Jim Crow, by lynching. by the nadir, by anti-Black racism, by Jane Crow, and subordination and oppression, and all of which shape the fabric of our society. So the legal profession is complicit. It is an architect of the scaffolding. Before we even get to developing a team, we have to know when law really picked up speed in the 19th century in legal education, except for a scarce few, anti-Black racism and oppression continue to deny Black people and women the opportunities to do these apprenticeships in the profession, in law schools, and to gain admission to the bar. Even our organizations that accredit us, the ABA, the ALS, respectively, pushed our Harvard model of legal education while tamping down those part-time law schools that actually serve Blacks, immigrants, and Jewish people. And so we've got to acknowledge this history that our legal education framework, that our cravat-style law firms, that our entire structure is built on this foundation. I mean, Black people didn't even get accepted into the ABA until 1943. So we have to reckon with that, wrestle with that, and then begin to form these teams.
Mm-hmm. And that is a tall order, but one that is belated, and it's a call to action there. Sarah, you allude to, like, what would you like to see as somebody, you teach first-year students, you teach upper-level students, on these themes of both kind of teamwork and inclusivity, and how could we change the traditional 1L classes, that we all remember, and frankly, that have been largely the same for 50 years, and maybe tweaking at the margins. What should we law schools do with those if we could, besides, that sounds like a tort law hypothetical, the train running down the track.
I'm sorry. Talk about timing.
That case has been taught every year for 50 years. Is it false graph, right? Oh my God. Okay,
I asked Amtrak to time it just accordingly for that, yes.
So with that, like what would, and you teach in so many different settings, and you're one of the best teachers in our building, virtual building, or first year classes. What should we do about the first year?
Well, so to bring up points that I think we've all have made about it being really divorced from the actual practice of law, and I don't even just mean that contracts should run through a contract at every single aspect of it and be very skills oriented, but rather not thinking about who these clients are, not thinking about who the lawyers are and what their diverse backgrounds are. The curriculum is very divorced from that. And I think the best lawyers are ones that have diversity in all ways, right? Diversity of prior experience, diversity of racial background, diversity of schools, diversities of ways of thinking. And unfortunately for many of us, I was a first generation student myself, I kind of just went to law school. It was kind of like Legally Blonde. I just showed up and I didn't know what to expect. And I don't even think I had the sophistication to know what I didn't know. And I see this happen with students fairly frequently. They think they're playing a different game than some of the students with a background that has set them up better. Political science, Ivy League school.
Should lawyer formation then start before day one of the 1L year?
Well, it does, just as a matter of practicality. But I think by breaking it up and not having the focus be so much on just the end goal, and instead giving that feedback throughout, actually, instead of only doing cold call Socratic method as a way of learning from each other, why can't we chunk the first year contracts class up into segments and we problem solve? Right? We talk about, okay, so if you're representing a client that has problems like the ones we've just read about for the past 3 weeks, how do we do that? And we can actually learn from each other in a real way and get feedback, because some of this happens in study groups and the like, but without the feedback of, well, yes, but have you thought about this, or have you thought about that, by someone who knows how to do it? And I think we've learned a lot in this past year about technology, and I don't know that we need to really use technology in a serious way to keep educating, But there's some real benefits to do that, and that our professors can work in different ways, keep some of the classroom aspects the same, but give feedback in a virtual way, in group discussion boards, in Zoom meetings that take place, outside of classroom time. So none of that is to say we really need to lower the standards here so that everyone can succeed. It's keeping those really high standards. It's just achieving them in a different way. This should be challenging. This should be difficult. And that should be part of what's so great about the first year of law school, is meeting that challenge and meeting those expectations.
Well, I'm sorry. Finish your thought. Yeah.
That was it.
Okay. No, you reminded me that sometimes it's actually the working with others, working with a team, that for some of our students is a challenge, and they need that challenge if they're going to succeed. I've had students who go off and take a Wharton class, and the success is not what it was in the classical large law school class, and a lot of it was because of, and so we try to train that as well. So Jim, as you hear this and you lecture on leadership, you've been a leader in so many different kinds of institutions, and my sense, and it may be yours, is that in the past decade plus, there has been you hear from leaders of law firms, law schools, you hear a desire for more inclusivity, a desire for more access. So maybe some of the thinking is in the right place, but yet the problems persist. And so that strikes me as a leadership problem when you're seeing some normative change, you're seeing a desire in our profession. I think that's widely shared, but yet the same patterns. So what's going on there, and what would your advice for leaders and others be when there's kind of a consensus that we ought to change, but we're still stuck in the same old patterns?
I think part of the problem is too many of the same types of people talking to too many of the same types of people. They need to broaden the discussion and reach out to other people that aren't a part of their usual networks to learn what they don't know. I've heard exactly the same discussions that are going on today about diversity and equity and inclusion, and the need to improve it in the law firm environment, that I heard 25 years ago. More people are talking about it now, and they may be talking louder about it, but very little has changed. And I think part of it is this siloing, this bubble. Why do you expect anything to be different when there are no new voices at the table? This should not be rocket science, folks. This is a solvable problem, but it does take leadership, engaged leadership, willing to reach out to others, to bring new thinking to the table. Look at this is the legal profession, and we are probably close to the absolute bottom in terms of our record of diversity, equity, and inclusion. We should be leading, not lagging. So let's recognize our failures, look at examples in other disciplines, other professions that are doing it better with a little bit of humility, and say, can you help us out?
Well, that's a great point and a great segue back to Danielle, because you also had a career as a leader in the military. I'll ask each one of you about maybe lessons from a particular other discipline. And Danielle, what did you see in the military that we could learn from? What are they doing well with respect to equity and leadership and changing you think of the military as a very traditional organization as well, but what do you see there that we ought to import into our profession?
Yeah, one thing that is distinct about the military is the immediacy of their mission and the problem solving. And so you have aspects that can go day to day, but when we look at January 6th and the mobilization of the National Guard, that was an emergency. And so what I've learned as a leader in the military is to be prepared both for the day-to-day and to be prepared for the crisis, the emergency. And the way we do it, very similar to what Jim was articulating. You have to practice inclusion. You have to speak it if you don't believe it, and get yourself to know it, and fake it until you make it. I mean, there's all that, and it's real. And that's what we do in the military. You're afraid, you're scared, but you still have to accomplish the mission. And so you set your objectives. I know you're wanting me to talk quickly about the ALS Law Dean's Anti-Racist Clearinghouse. Well, instead of being paralyzed completely by the cascade of killings against Black people, we came together and we said, we are going to create anti-racist law schools, and here's how we're going to start doing it. And similarly, even though the elephant is big, we are going to take one bite at a time, and we are going to create programming to do it, and we are going to teach ourselves what we don't know about the history that we've either ignored or not been taught. We're going to get out there and we're going to get our hands dirty and we're going to get our feet wet and we are going to just muscle through this. And that's, I think, the difference, at least my experience as a lawyer in the military versus my lawyer role in the legal profession. It's immediacy and it's mission and it's a commitment to mission.
Mm-hmm. Yeah, that's really well said. And it reminds me of another ex-military friend sent me an article early on in the pandemic that's been so helpful about how decision-making in a pandemic is kind of like military decision, where you need to focus on your values and your mission and be prepared, as you said, Danielle. But things are going to change, and the best laid plans are going to go awry. And too often, when we do try to plan in academia, or we have these big 2 or 3 year plans, and so I think that that notion of having your values set and your commitment set, but not knowing exactly how it's going to play out is so important. And I think we're proud here of some of the innovations we've done. I'm almost as proud of, we tried something we thought was going to work out wonderfully with having our LLMs on a calendar year schedule, and we think it did work for this year, but we're just not going to do it. So just some of my colleagues gave me good advice to, okay, this was a good try, but maybe that idea didn't. So the notion of always experimenting but being ready to adapt is very much like the military, I think. And so Scott, I know can you elaborate some more? Are there specific things that come from the world of business or consulting that you want to foreground? And Sarah,
business consulting, building upon what Danielle and Sarah have been saying, the best organizations are learning organizations, and they learn through constant feedback for development and growth. The law school model, the only feedback given, especially first year, is basically to evaluate and rank you for the benefit of employers and judges, and for faculty to use this our Darwinian system to figure out who are the smart people, meaning the people who think like I do. Jim, back to your point about this is a really narrow group and a bubble. And then, of course, it perpetuates that way. We don't get new voices or new thinking. The consulting world, McKinsey's giving feedback constantly, and people are learning and growing and developing. I think it's absolutely critical. We learn that in the military, as the teams are working, your after action review, what went well, what didn't, how are we going to fix that? And it's very inclusive. Every soldier in the unit is participating that way, and then the leader of the unit, the lieutenant, the gunnery sergeant, they're going last. Like and it takes 20 minutes maybe, but they do this religiously because they understand if they talk about things, they learn and grow that way. And again, the message too, lawyers are particularly resistant to feedback when psychologists study lawyers. We have a very defensive immediate reaction as high need for achievement people. Our amygdala gets triggered, we get defensive. The way to break that down is to have it be a regular part of the team process, and then individual feedback is not as scary. And that's how those organizations do it.
Great. And I would amplify what's being said in the chat. That we appreciate your questions, and we'll move soon to a Q&A format led by one of our students, Linwood Shaffer. And so on this theme, Sarah, you teach students who work in different fields, and you practiced. And so again, what do you try to import from other fields in which you're expert?
Yeah, and part of what I'm going to say is going to pick up on one of the comments that we got, which is, clinicians teach this way every day, and it's so true. And one thing I guess I wanted to sort of level set and say is that one of the most wonderful things about teaching here at Penn Law has been the support from TED in particular and the administration generally in those who are coming from practice, right? People in our legal practice skills program and our clinicians, the level of trust that we're given with our students, mostly in the upper level curriculum, but in our first year, fall and spring legal practice skills is significant. And we have been given a lot of free rein to design programs that do these very things, that are iterative, feedback-based, truly inclusive. And so we are doing this work. It is happening. It's not in every class, in every law school, but it is happening in a real way here at Penn. And And one of the things I think about is, again, coming back to those high standards, one of the questions was about winning, and not to jump into the Q&A, but are we really preparing students then for a really competitive environment that they're going to enter? And I think the answer is yes, right? Coming up on what Scott said about lawyers being really bad at feedback. I may have been one of those lawyers who was really bad at getting feedback. It is a difficult thing to do, and we need to teach young lawyers how valuable it is and the ability to take it and incorporate it. And that's a lot of what we do in my first year class. And that comes from my own practice, right? That the best ways that I learned were from people who took the time to actually care about my development and push me in ways they thought that I needed to be pushed, and knew my strengths and my weaknesses. And that's what we try to do in knowing our students so well, in knowing their work, in giving feedback on that work and giving feedback again. We're preparing them for that world, and I want them to win, because that's what fun is being a lawyer if you can't zealously advocate for your client and get an amazing outcome for them. It is truly rewarding, but a lot of that is not operating in a silo, and a lot of that is not drawn from being good at being on call for the Socratic method, but learning from the team that you're on, the team of lawyers that you're on to represent a client in a really challenging situation. And I think we're doing that here. Still more ways to do it, but that is the goal.
Yeah, and I think that's important, and I value the question. And sometimes I think, and this is maybe I'll call this the old model of thinking, when law schools being very undiverse used to first start thinking about inclusion, 10, 20 years ago. It was kind of almost in tension with the professional goal, which is just radically the wrong way to think about it. So I know all the panelists, we've talked about this, and when we talk about building an anti-racist law school and exposing all of our students, particularly those who've grown up in the kind of privilege that I have, about other difficulties and challenges, that's to make better lawyers, and that will make better lawyers and leaders. Indeed, going out into practice kind of oblivious is the wrong recipe. Likewise, teaching you about teamwork and other skills other than just sitting in a large classroom, that's about making you a more well-formed person, but also that will make you a better lawyer. And you see, I see people get into trouble if they try to, be too focused when they come out of law school. Jim, one field that I've studied, and I know you have, that it gives me hope, because if you would have taken a snapshot 10, 20 years ago, or for the whole 20th century of the medical profession, you look at how hierarchical it was, how inefficient it was with the fee-for-service medicine, how they didn't really take criticism very well. They didn't really change their practices. But they have changed in the last 10 or 20 years in ways that I know you have looked at. So as we think about lessons from other fields, we've heard about the military, we've heard about business. What about the healthcare professions, and what do you see there that you'd like to see in the legal profession?
I think there are a lot of lessons there. The most important to me is how they've differentiated service delivery in a way that we haven't in the legal profession. Restrictions on the unauthorized practice of law really limit who can provide legal assistance to people who need legal help. But in the medical profession, you have not only doctors, but you've got licensed practical nurses, registered nurses, physician's assistants, phlebotomists. If your doctor at your physical came in and went to take your blood today, you'd say, "What's your problem? Don't you have something better to do?" You wouldn't say to the phlebotomist, "Aren't you engaged in the unauthorized practice of medicine?" There is a way to provide competent, ethical help to people using not just lawyers. Regulation of the legal system has constricted the supply in a way that leaves too many people with no help of any kind, simply because they can't afford a lawyer. I think the medical profession has done it in a way that is regulated, that ensures competence, and provides much better service to patients than they did 40 years ago. So yes, absolutely. Let's look at them as a model. Yeah,
and as we've talked about before, think about this: the trust we have as a society in the role of the nurse. Okay, even that's a high status. It's a respected occupation. There's no analog in law. Like, we don't even have the right name. Paralegal is probably not the, so we do need this kind of professional, we haven't even have a conception of it. But in medicine,
it's worse than that. We have the term non-lawyer. There is no term non-doctor.
Yeah. Right. All right. So we'll shift over to more explicit Q&A soon, and I'll hand off to Linwood. But let me ask each panelist. I'll start with you, Danielle. We'll close with each of you sharing one idea for different kinds of audience members. So, and I'm particularly interested in your answer because what's your advice for law school deans, Danielle?
Oh, you're making me giggle. So my advice for law school deans, and I would love others to listen to this advice. Can we move away from elitism in the profession, undergirded by rankings, so that we can realize a future where Jim has given us a beginning path toward by saying the rule of law belongs to all of us and we can have a role in it. And here are the roles. And in that way, we might be able to hurdle the overrepresentation of whites in the legal profession, while at the same time grappling with the severe underrepresentation of people of color in the legal profession, because we are facing a crisis. We are facing a crisis of democracy. We are facing a crisis in our profession, and we have to open our eyes to that. And Jim has given us one path forward to begin to address that. And I would tell law deans, listen to this conversation, listen to what the contributions have been today.
Mm-hmm. Thank you, Danielle. And I would actually say, I want to foreground, besides just that being an inspiring, thing for us to keep working on. I want to admit the most challenging thing you said today, is you said a lot of motivational and challenging things about anti-racism and moving away from a whiteness-defined profession. I have to say, though, as the dean of this law school, what you said about moving away from the hierarchy of law school rankings for Penn and for Professor Westfall's school, that is I got to say, that's jarring, right? You're right, of course you're right, but it's a vernacular, that it's in some ways a more novel vernacular at places like the University of Pennsylvania, even than the belated anti-racism dialogue, because we'd like to be anti-racist and still ranked at, in the top 5 or 10, but to really expand access to justice, we need to care less about the rankings. I agree with that.
And if I could quickly follow that up with.
For sure.
It was hard for me to say, but we got to dig deep and find the courage.
Yeah, thank you. Scott, you're going to address a difficult crowd, and some difficult in the sense of, leading these big institutions that are tough to change, maybe even tougher to change than law schools, is law firms. So law firm leaders, what advice do you give to them, Scott?
Yeah, this is my day-to-day job, and our executive education program is all about this. I start with the idea that we have to recognize that leadership development has to occur over the arc of a lawyer's career. Every other profession has a tradition of, regularly stepping back and reflecting, what role am I taking on next? How do I prepare myself for that role? My dad was a nuclear submarine captain. Every time he was getting a promotion, getting a new stripe, they took him offline for training. He prepared and he was better at doing that. My sub agenda there is to say, if we actually succeed in creating better leaders, they might be able to re-engineer the way we work. The model for working in law firms as an anchor point of white men with wives at home, working, exclusively, over a 7 now to 12 year period to make partner, full out effort, concentrated in that part of their career. And it is driving so many people out of the profession, because we're working in these hierarchical ways that don't create meaning and purpose in the work, that don't give regular feedback and help people learn and grow, and that are not diverse and inclusive. We're not making any progress, as Jim said, on diversity. And we're also causing a lot of, depression, substance abuse, all of the things that people find human energy in. Right now in this COVID environment, it's getting worse and worse. And I'm hearing every single day from former students of mine at big firms. They reach out because I know that environment, and they're devoid of purpose. They're devoid of meaning, and it's just tragic. They're really smart people who do a lot better than that.
Yep, thank you. Sarah, I realize I kind of preempted part of your thunder in terms of the first year, the advice to first year teachers, but let me frame it a little more precisely. You've given us good advice about how to enrich the first year. How would you address, and then maybe this isn't a hypothetical in our hallways, how would you address a skeptical first year teacher who thinks they've been teaching and say, why should I change my model? What's the pitch there?
Oh, Ted, that is a huge challenge. Look, I think I'm realistic in that for some folks, that's not going to be something they'll be able to be convinced. But I will say, looking at this year of just challenges around every corner, and even our most stuck in their ways professors having to adapt, right? Because we're teaching on Zoom. We can't all be in a classroom. No one can come up to you after class and ask you a question at the podium, and having to learn to deliver in a different way and doing so successfully. Pointing to that as saying, look, it worked. You had to change. You kept things largely the same, but delivered in a different way. Keep the things that you had to adapt to that worked, leave behind the things that don't, and build on those things that worked. You found different ways to connect with your students because they couldn't come up to speak to you after. Keep doing that so that you're reaching out to the students who don't feel comfortable coming to office hours because they've never sat in a room with an academic like that before and don't feel the confidence or feel the sense of belonging to sit in a professor's office hours. So formalize some of those outreaches you did, small group breakouts on Zoom, discussion boards on Canvas that you didn't like, but you had to do. Keep building on them and growing them, and you'll get much more buy-in from your students and stronger relationships and more depth of learning.
Thank you. Well, and we'll work together, Sarah, to talk to our faculty on that. Jim, so yours is similar to the question I asked Scott about law firm leaders, but outside the law firm context. So public interest lawyers, groups, general counsel. And so we're regressing out some of the problematic structures Scott mentioned, like the partnership structure, the billable hour, but yet it's still not easy to promote change. And so what's the residual resistance, and what advice would you give to lawyers practicing in organizations outside of, or leading organizations outside of traditional law firms?
Leadership in law, in whatever environment, law firm or otherwise, is stultified by its insularity. Law firm managing partners talk to other law firm managing partners. Legal aid executive directors talk to other legal aid executive directors. I imagine law school deans talk to other law school deans. We have to establish regularized ways for leaders in law to talk to leaders in business, to talk to leaders in the nonprofit sector, in community organizations, in financial services, in academia. We can, in the consulting firms, we never talk to them. And many of them do things much better than we do. When we no longer have roundtables of law firm managing partners, but instead have roundtables of leaders at which lawyers are represented, then we can begin to make more progress.
Terrific. Well, I'm going to transition. The panelists stay on. We want to continue this tremendous conversation, and I'm going to step off in a minute, and in will step a terrific third-year student, Linwood Shaffer, who I would note, besides just being an excellent student here at Penn Law, is really, in a sense, in an effort to reform his second profession that needs entrenched reform, and that is that Linwood is trained as a certified public accountant. He worked for PricewaterhouseCoopers. He was the president of the National Association of Black Accountants. And so, Linwood, I don't know which is harder to change, or what's next. What other, maybe you'll run for U.S. Senate or some other body that is deeply resistant to change. But as both an accountant and a lawyer, you kind of embody the best of our interdisciplinarity. And I appreciate you taking over from here and leading our panelists through some really good questions that I see on the Q&A. So I will step off. Thank you, Linwood, and thank you to our panelists. And I'll be listening with interest and then join some of you in the discussion afterwards.
Thank you, Dean Ruger. First, I would like to read the next CLE code. So the next CLE code is Scooter, SCOOTER. Again, Scooter, SCOOTER. So I've been monitoring the chat and we have a number of good questions. The first question that I'd like to ask is actually directed to Dean Conway. And Dean Conway, this is from a law student. And how would you advise law students to, what can we specifically demand from law schools to foster anti-racist learning environments?
Thank you for that question. And I am excited that it came from a student professional. So the first thing that a student professional can demand from a law school is really, what is that law school going to be for that student professional? And to explain that clearly and unambiguously. The second thing that the student professional should demand from the law school is a relationship, a network. So we heard Scott Westfall talk about creating and nurturing and cultivating teams. So to think more collectively about a community's response to the challenges that Ravi Kumar talked about at the beginning. And then the third thing is you want to make sure as a student professional that you demand to be seen, that you demand to be heard, and that you stay in the discourse with your community members, no matter how hard it is, because the people in your law school community need the teaching and learning that you can provide as a student professional.
Thank you very much, Dean Conway. The next question that I would like to go to references the ABA accreditation standards that have seemed to stifle innovation in sorts that the panel has mentioned. So what can the panel members speak to specifically what needs to be changing or what is changing on the ABA's end?
Okay, I don't want to monopolize the Q&A, but I will say that this year has been a galvanizing year for deans as leaders and how we interface with the American Bar Association. So we are in now constant, as I mentioned from my last advice, we are in constant discourse with the ABA. I mean, we are taking surgical strikes at ABA standards. And this is good. It is not about annihilating the ABA. It's about knowing the ABA history and knowing what our roles as leaders are and going through those standards and say, are those standards consistent with what we value as legal education? So do we really value 3 years of sitting in your class seat and learning from a sage on the stage? Or do we value internships? Do we value classes that teach us reflections like we have at Dickinson Law, context and competency classes? Do we value the culture of apprenticeship? Well, that should be in the standards. And let me say one more thing about this bar exam. Is that really the test of competency for the practicing lawyer? I could go on, but I'm sure others would like to pick up where I left off.
Does anyone else want to react?
Yeah, the protectionism, and the history of the ABA that way is truly incredible, Jim, to your point about how do we broaden the idea of who can practice law and how there's so much resistance there, that needs to be broken down. And I'd be curious about your thoughts about, is there a way? I know there's some efforts right now to relax restrictions on who can be a partner within a law firm, who can share profits within a law firm. Could it be a non-lawyer, for example?
Yes, there are developments underway there, most notably in Arizona and Utah, but they're outliers. There is a ton of work to be done, and protectionism is alive and well.
Great. Were you going to say something, Professor Pierce?
Oh, no, I was just going, the only thing I was going to add is to give some kudos to Jim and to Dean Conway, that these are really systemic issues. And I think we're really lucky to have people working from within the system to change it, because I think that's one of the only ways it will happen. And I just would commend their efforts to do that.
Awesome. So the next question speaks to, and this was briefly mentioned throughout our discussion today, but can the panelists speak to wellness factors in the formation and training of lawyers? And more specifically, how do we make sure that our legal training models don't contribute, but actually help resolve some of the issues seen in the profession, such as substance abuse and depression, that are often a result of the pressures faced in the profession?
I would just add, and I think Jim probably has a lot to say about this, given that he focuses on this a lot in his professional responsibility course. But I know that in several of our courses here at Penn, focused on professional responsibility, wellness is a significant part of that, because I think we can't be good practicing lawyers and adequately represent our clients if we're not caring for ourselves. I'll say it's a challenge, and it is one that been out of practice 5 years. My husband's still in practice. And so being in the time of COVID, I hear it 20 hours a day, right? It is tough, and it's getting tougher all the time. And so it's a challenge. And I think changing that for this generation that's coming up, and hearing students say, it's one that I don't think I can accept. It's one that I don't think I can do for the next 25 years is hopefully a start.
And what I try to tell my students is that, the studies on law student depression show that they enter law school with a pretty much the same relative rate of depression as others, but by third year, it's a much higher rate of depression. And it's sad that the single most correlating factor is their locus of self-worth moves from intrinsic, internal, who am I, what are my values, what matters to me, to how the external world is judging me, and how am I ranked, and what offers did I get, and what clerkship did I get. And the competitiveness, again, that's driven by that individualistic model and feedback only for rating and evaluating people, for the most part, outside of the clinics and the wonderful work that people like Sarah are doing. So I'm teaching a class on resilience right now, and that's what my students are talking about. It just brings them down in a way that is completely unnecessary. One of the things that occurs to me is, I don't know, our law school does not have a mission statement, and I really wish it did, because the mission statement ought to include something about, helping people to thrive and then become very successful lawyers in whatever practice setting they decide to enter. And we miss that completely and don't seem to care about it.
Penn places a lot of emphasis on this, as I think any law school has to. But the question is the right one. To what extent is law school contributing to the problem? And I think we're for a lot of self-reflection. If you were to ask me what the biggest cause of stress among law students is, I'd say it's the exam model. It's what Scott just referred to. It's everything riding on a single exam, and then you get a grade, and your job prospects depend on a ridiculously small number of grades. It doesn't have to be that way. That's not built into any law anywhere. So I think that the effort of law schools to get on top of this issue has to start with a lot of reflection on how law schools themselves can begin to model behaviors that will reduce stress and not contribute to it.
I think too, to build on that, Jim, what do we celebrate? We celebrate the graduates who become professors and clerk of the Supreme Court and everything. We don't talk about anybody else and their path. We have a wall at Harvard where all the faculty photos are, and you walk in there and it's like, okay, you have failed first year if you don't have the grades that will qualify you someday to get an appellate and maybe a Supreme Court clerkship and come back and teach. We don't celebrate anything else about what our graduates are doing. So.
And I'll jump in and say, this point of imagery is so important. My colleague and former dean, Gary Gilden, removed pictures of people and put up art from MoMA and from, just all kinds of art just to inspire the space. And I agree with him wholeheartedly. When you look at who we revere as lawyers, it's when I go into a courtroom, I see old white men. When I left my deanship at the University of Maine School of Law, I insisted that they put my picture up. Not because I think this is all important, but because it disrupted the narrative.
Well, I just want to thank the panelists for your responses for the Q&A. This concludes our Q&A portion, and I would like to turn it back over to Jen.
Thank you so much, Linwood, for the great questions. Thanks to all of our audience members for posing them. We know we just scratched the surface, so I hope you'll stick around for our post-webinar discussion. And on a personal note, as somebody who was absolutely the student that Sarah described earlier and thought that she had nothing to contribute to this profession, I was absolutely the student that Scott talked about, who was depressed and anxious as a result of the model that Jim referred to, sitting for one exam and feeling like everything is riding on it. And somebody who just really wants to celebrate all of the lawyers and all of the talent that comes to us, as Dean Conway referenced, so that we can elevate the profession and drive all of our students forward. And as Sarah said, raise the bar for everybody. I'm just so thrilled that we have leaders like all of you in the profession really advocating and making real change every day. So I look forward to continuing to work with all of you around these efforts. And many, many thanks at the end of this series to Naoshi Giles from our conferences and events team, Dalila Lewis from the Future of the Profession Initiative, and our partners in ITS for helping bring these great conversations to life. We'd love for you to share your feedback about all of these conversations, and the survey is linked in the chat. And we're going to take a quick break now, but we hope many of you will join us to continue exploring these topics. You can find a link to the Zoom chat room for the post-webinar discussion both in the chat, and you should also receive an email from us around 4:25. So we hope you'll join us then. Thank you for attending. If you're not able to join us at 4:30, we hope to see you in the future. Be well, everybody.